Welcome to our YouTube video series on legal terminology. In this particular video, we will be looking at the term sine die, which is frequently used in connection with a court adjournment. The legal term sine die is taken from the Latin without day and means without any future date being designated, as for its resumption. As such, where there is a proceeding or meeting, be it a court proceeding, arbitration hearing, parliamentary session, or business meeting, which the involved parties determine to adjourn or postpone to a later date, yet have not committed to any future date, such that they are holding off indefinitely until the parties agree or are otherwise directed to set down a new date upon which to recommence the meeting or proceeding. Certain criminal proceedings can only be adjourned to a maximum number of days, such that adjourning those particular criminal proceedings sine die, hence indefinitely, would run contrary to the prescribed Criminal Code of Canada limitations imposed upon the Crown to set down the matter for its resumption prior to a drop-dead date, as seen in the Supreme Court of Canada case of the Crown versus Krannenburg, citing the Queen versus Morse, the Queen versus Quinn, and the Crown versus R. Another scenario of sine die arose in the Supreme Court of Canada decision of Canada Broadcasting Corporation versus Manitoba, involved a lower court ruling that was appealed on multiple grounds, and the Supreme Court of Canada made a determination as to one of the appealable aspects that required the matter to be remanded to the Court of Appeal to decide that appeal, as it was, quote, best placed to decide the discretionary and fact-specific issues raised, end quote, such that during the pendency of the matter being remanded to the Court of Appeal, the second appeal would be adjourned sine die, given that the preceding aspect needed to be fully resolved before anything could properly be undertaken on the second aspect being appealed, the purpose of which is to overcome procedural difficulties. Quote, appellate courts have used the sine die adjournment to deal with appeals identified as premature due to ongoing proceedings below, which ought to be completed before the appeal is heard. End quote. Thank you.